I'd like to call the meeting of the July 18th Board of Canvass meeting to order. Madam Clerk, would you do a roll call?
Member Giavoni.
Here.
Member Tuffy.
Yes.
Jim Hedia.
Here.
And Member Orberg is excused from this meeting.
Okay. First thing on the agenda is approval of the Board of Canvass meeting minutes from May 16th.
I make a motion to approve the May 16th Board of Canvassers meeting minutes.
Second that. All in favor?
Aye.
Aye. Okay, discuss the reconfiguration of Bull County Road School for the September 10th, 2024 primary election. Okay, to begin with on this, myself and Member Toppy met with school representative Mencucci, and we were looking at alternate entrances and exits for the on that election day. Going over all of that with Mr. Mencucci, we were looking to go through a side door, which was not feasible because that side door actually goes through the library. So that was not a feasible entrance. What we ended up discussing was having two entrances, one being solely for the handicap, which would be the front doors. This has to be run by the Board of Elections. They would have to come out and approve that. And what we plan on doing, and we will bring this up to the Board of Elections, is to have that front entrance solely for the handicap, and we would have to do a multiple of signage to make sure that no one else would use that entrance. And the side entrance would be the entrance for the other voters. So we're waiting word from the Board of Elections. I will meet with them along with Mr. Mencucci and to seek approval. Now, the law says that we have to use the same entrance and exit for the voting location. But being that the voting location is actually in the gym in Old County School, I think we could probably get by using the outside entrance and still having the same entrance and exit for the gym for the voting location. And again, that has to be approved by the Board of Elections. Anything, Chris, you were there?
No?
Is that pretty much
That
it?
is, yep.
Okay. Moving right along. Consider, discuss, and act upon the caterer for September 10th primary election. Madam Clerk.
Not much for me to say. We've got the three proposals, and there is one that we're still waiting for. Now, that's our usual caterer of Isola.
You did put it as my zone, you were questioning that, okay.
So I don't know if you want me to give it one more shot, try to get in touch with him. I don't know if he's away, he hasn't responded.
No, I don't think we have to wait for them.
Okay.
Okay, if you could just go over what we have for the, we have three here.
Yeah, I have Dave's, let's see, I have the Sandwich Shack, and I have Papagino's. The only thing I'm not sure about is Dave's. There is potential for them not to deliver. That may be something we would have to go pick them up and deliver them to the locations.
I think we discussed that, we would be happy to do that if that is needed.
Okay, so that would fall upon the board to do that, members of the board.
Yeah, I mean, if at all possible, or if I can spare someone to, or, actually, if they could deliver it right to the clerk's office, we can disperse them right from
Disperse from
there.
there.
So that's a thought.
Yeah, that would probably be,
Okay.
Yeah, ask them if they can deliver to the one location,
Yeah, that's
and we
fine.
can go from there.
Sure.
If it needs to be picked up from the store itself, I wouldn't mind doing that.
Mm-hmm. Now, they seem to be pretty accommodating. I'm sure I can get them to bring it to the clerk's office and get separated and get them off from there.
That's only for Dave's, correct?
Correct.
Okay, so the number is given for Papagino's, the total price would be $902. And that would be for 35 total dinners or lunches.
And 70, right?
So,
70.
About 35
Oh,
turkey
70,
and
I'm
cheese.
sorry,
Yeah.
you're correct.
And 35 ham and cheese.
Correct. So that would be for 70 and the 6 pizzas for the evening meal, one to each location.
they will deliver and they also give us a 20% discount.
Okay, so their total is $902. Okay, and this one is
This is the Sandwich Shack,
the sandwich shop.
which is a new sandwich place opened this year.
So their total box lunch would be $1,046, but when you add the pizza, the total comes to $2,200.
Yeah.
So that's a little bit over our budget. So we can take that one out. And Dave's, and this is for 70 also, correct?
Yeah.
Okay. The total there would be $1,063.38. And that would be for 6.
12.
I'm sure we need 6 pizzas then, or 12.
I think it's 2 pizzas per location.
That's what we have, like,
Yeah.
we can
Well, I
discuss
thought
down
we-
the
I
line,
thought we
like,
discussed
we had
that.
an awful lot.
There was,
Oh,
right, we dropped that down to 1 pizza per location.
Yeah.
okay.
So, okay, so Dave's would be, Dave's was with 2 pizzas or one?
Well, all the prices I have here are with 2 pizzas. Well, this one was per person, so can't count this. This
Right.
one's out
That
anyways.
one's out.
But this is also for 2 pizzas. I added this amount.
Okay,
So it would be cut by approximately $90 if we don't get
If
2
we go with
pizzas.
one, okay.
Yeah.
So round it to 100 off that total.
Okay, so it looks like,
Same here.
it still looks like Papagino's is still the best
The
price.
cheaper option.
Yeah, and, you know, I think they have a good product, so, do I have a motion?
Motion to approve Papagino's.
Second.
All in favor? Aye.
Aye.
Okay, Papagino's is the place. Okay, certification of nomination papers for the September 10th primary election.
I have all the nomination papers here, you go through. I also have the codes, which is what we code them by. A blank line, somebody that's not registered, a signature you couldn't read, et cetera, et cetera. So I have a copy of that, that's how those are coded. Pat, after the meeting is gonna go down to the SOS, drop off the federal and state nomination papers, local stay with us. So, again, these are all your goodies. And Charlie, that is the letters that will come with,
Clerk's office has perused all of these, everything is in order.
the clerk's office did the nomination papers as they came in, and we sat down this week, as a matter of fact, for 2 days, and went through them again as well.
Peruse these, Let's take one piece.
Okay, yeah.
And if there is anyone that you question, I can certainly, maybe downstairs, or if you want to actually see like matching signatures, we can do that as well.
discrepancies?
There were activists opposed.
Okay, so is there a motion to certify the papers?
Motion to certify.
Second.
All in favor?
Aye.
Okay, consider, discuss, and act upon a letter from Democratic Town Committee Chair, Lawrence Mancini, requesting a replacement to fill the town council candidate vacancy. I'm sorry,
Mr. Chair,
I missed one.
Mr. Chairman.
Yes.
I have recused,
Yes,
and with respect to the last two items, I suggest that they be heard at once combined because they are legally, they're interrelated. So,
So you want to combine, okay. Okay, the acceptance of the withdrawal of Joshua Michael Accetturo, candidate for town council. and consider, discuss, and act upon a letter from Democratic Town Committee Chair Lawrence Mancini requesting a replacement to fill the town council candidate vacancy created by Joshua Michael Accetturo withdrawn.
So for the record, we have two letters, one from the Republican Party Chair, Mr. Bellotti, and one from the Democratic Chair, Mr. Mancini, regarding the issue of a potential substitution of a candidate. Mr. Mancini is looking to replace a candidate that was disqualified, who was ineligible from running from the beginning based on the statute 1713 and 1714-2, because there's a 30-day period in which time someone needs to be registered in order to even be able to declare to be a statewide or local candidate. Mr. Mancini is going to present, he should come before the board, present his arguments, and then we'll allow Mr. Bellotti the opportunity to present his arguments and discuss it.
Okay, Mr. Mancini?
Thank you, Mr. Chairman, members of the Board of Canvassers. So, for the record, I had sent a letter in dated July 15th, it was received by the clerk.
Why don't you mark that as petitioners one?
Thank you. So, Mr. Chairman, the letter was meant to serve both as a request for hearing and also a formal complaint on the practices and procedures that were improperly displayed by the town clerk's office.
I can.
Permit me, if you will, various times in this matter, I will cite the exact conversation that I had in my letter, but that will be for the oral testimony and for the oral record given today. While the solicitor cites certain rules, there is a rule under 17-12-2 that permits the party to replace a candidate that is ineligible within a 24-hour period on notice of that ineligibility. By all practices and procedures in every town clerk, board of canvassers offices in the state of Rhode Island, that process is to commence and complete during the last day, no later than the last day of declaration. In the case of the Smithfield Town Clerk's office, the town clerk, with due respect, was on vacation.
Larry, can you speak up a little bit?
Sure. In the case of the Smithfield office, the town clerk was on vacation. Her deputy was not available when I walked in at 8:37 on Wednesday morning, June 26th. I have to lay the foundation why I have high objection to the practices and procedures, and in some cases, with due respect, the incompetency of the process in the town clerk's office, thereby precluding me from that privilege of replacement under 17-12-2. Literally disenfranchisement of the candidate or replacement. When I walked in at 8:37, I filed all 7 of the major candidates, 5 town council, 2 school committee. In addition, I had 47 members of the Democratic Town Committee. While standing at the counter, I was informed by a clerk that 16 of the 47 town members were unacceptable and were returned back to the chairman because they couldn't be accepted. I've been the Democratic chairman of Smithfield for 22 years, 8 years previously in the city province. I'm well acquainted with the process for filing declarations. With due respect, I protested and said, why are they being sent back? I was told because they were dated before the opening of the declaration period of Monday, June 24th. That's not what the law says. The law says they cannot be filed any sooner than the opening of the declaration period. I myself signed mine the day before, on Sunday, June 23rd. On Monday evening, by tradition, the Democratic Town Committee held its nomination committee meeting and endorsement meeting. The nominating committee had met during the week. They had its report entered into the record on Monday evening of a properly convened meeting of the Smithfield Democratic Town Committee. Nominations were entered in, voted upon, candidates spoke, endorsements were provided. The paperwork was completed, signed by all 4 officers of the Democratic Town Committee, with expectation that they would be filed no later than Wednesday at 4 p.m. I walked in at 8:37 Wednesday morning. Plenty of time to check 7 names of prime candidates, let alone the 47 additional Democratic candidates, and I trust the candidates for the opposition party. Due to another commitment, I left that office, but I was not certain that that interpretation was correct. I checked with a member of my town committee. Furthermore, I called the Secretary of State's office, spoke to the Deputy Secretary of State, who said absolutely, positively not. They are wrong. That's incorrect information. He called the town clerk's office and spoke to the deputy and said, that's the wrong interpretation. Those forms are legally filled out and they should have been accepted. I then get a text at 12 o'clock in the afternoon that says, sorry, we made a mistake. Sorry for the confusion and inconvenience. Can you please return back to town hall with all the forms you had originally submitted? I dutifully returned to town hall and did that by about 1 o'clock in the afternoon. By 3 o'clock in the afternoon, I was checking with the town clerk's office to see what the progress and the process of that particular endeavor was. I was told in the text in my letter, yeah, trying to keep up. I said, I noticed that there are only 32 names on the Secretary of State's website as having been accepted thus far. I filed 47. I was focusing on the town committee. I know, we're trying to keep up. Let me submit for the record that I know I have checked with other boards of canvassers, including the capital city. This is how the process works. You submit a declaration. The first thing that the clerk's office is supposed to do, trained or untrained, is to go into the centralized voter registration system, CVRS, uniform throughout Rhode Island. You punch in the first name, maybe the second name initials, and it pops up with a list of codes. The clerk just listed some codes with due respect. The codes are either A for active, I for inactive, P for pending. If it's P, it's unacceptable. That process takes 1 second, 2 seconds. 7 names, 4 of which were already well known to the town clerks. They were either incumbents or had run previously. I stress this because the confusion created by the clerk's ineptitude on Wednesday led to an improper decision. Let me jump ahead. Not only did I not have the opportunity as the gatekeeper should have allowed me that privilege to say, this person is ineligible. Because it's standard process. You reach out to the state party chair, they give you the privilege under their authority, and they will replace within 24 hours. This Democratic chair was not notified until one day after the preparation of the nomination forms, which you so carefully examined this day, and you accepted as having them been done in proper fashion. I wish the same due diligence that we used on those nomination papers, to clarify that, was used beforehand. I was notified at Wednesday, July 3rd at noontime, that the candidate in question was ineligible after they had already printed, published, audited, and circulated his nomination papers on Tuesday, July 2nd. They were already out in the community with the ineligible candidate's name on there, and nobody gave notice that they were ineligible. So in this process, what I'm looking at is the due process. We have been denied due process in that. While the solicitor has given the citation of law, I'm very well acquainted with the law. We would be seeking relief under that provision that under 17-12-2, we should have that right. We've been denied that right. And the town clerk is the gatekeeper. Under 17-14-1, one of the duties of the town clerk in managing and accepting and verifying candidate submissions, it reads in part, the signature shall be accepted as valid if it can be reasonably identified. You can only identify it by looking at signature cards or checking records. To be the name and signature of the voter it purports to be. A variation of the voter's signature by the insertion or omission of the middle initial or titles or names shall not in itself be grounds for invalidation of the signature. But at a minimum, those declarations should have been tested for verification, validity, and of course eligibility. Once notified of the action of the town clerk that he was ineligible, I notified the candidate withdrew. He withdrew on the 5th of July, one day after the holiday. I was notified one day before the holiday. Based upon that, I wanted to provide you with that. The nomination papers were picked up by several of the endorsed Democratic Council candidates and school committee, and they began the circulation of these nomination papers in the community with the ineligible candidate's name on them. for the express purpose of seeking the necessary 50 signatures for local candidates to have their names qualified for place on the ballot. As I reported earlier, it wasn't until Wednesday, July 3rd, 11:55, that the town clerk, Ms. Antonucci, contacted me to inform me that the candidate was ineligible. Totally unacceptable. Totally unacceptable. Not just not noticed the day of the declaration deadline or the day thereafter for privilege of replacement. One day after the publication and issuance of the community, it's a high embarrassment. But let alone, it's a depriving of the right to have that candidate replaced. With the withdrawal, that draws us to section 17, 15, 38. Technically, the Democratic Party did name a nominee. It went through the formal process and submission. Technically, the nominee was put on a publication that was circulated in the community. His withdrawal technically constitutes another issue. This is all about ballot and ballot inclusion and deprivation or denial of the right to have the candidate. The opposition party suffers no loss. They only filed 4 candidates with endorsement, intentionally. The Democratic Party, by process and by history, always files 5 candidates. I did have a replacement candidate. I have submitted a name to the town clerk already. She asked me, what's the name of the replacement, should this be the case? The point being that this is a ballot issue, and because it's a ballot issue, there is no primary in Smithfield issue. No Democratic primary, no Republican primary. We are not pressed to have the ballot printed in a timely manner to appear on the September 10th primary. This is all about the names that will appear on the ballot in November, technically and theoretically. Therefore, under 17, 15, 38, either in the case of death, incompetency, or withdrawal by the candidate, the nominee, and I continue to use the word nominee because the clerk's office put him on a nomination paper and began the process of circulating them in the community. Despite his withdrawal, his name continues to be on those papers and he's certified to it, because that's how the signatures were gathered. His withdrawal allows and permits, in my opinion, the ability to replace, because it says so. Within 3 days of the party primary, there is no party primary, so that gives you all until September 13th to name and replace because this person voluntarily withdrew from the race. So there are 2 issues here. It's 17-12-2, in my humble opinion, 17-15-38. It covers a lot of ground. I've put all the facts in my letter, and I've attested to it. I'll be legally sworn in under oath if I have to. The clerk is here. It was unfortunate that she took a vacation that week, and I'm not signing her out personally. It's unfortunate that there were not members of her staff that were equally trained in the knowledge of election law. This is a basic rule, a basic right of election process. The party chair does not have the same ability as the clerk to determine the eligibility of the candidate on site. They were interviewed, they were asked how they registered, the answer was yes, et cetera, et cetera. Point being that in an instant, if you walk in and you look at a candidate's declaration, the clerk's office, in this case, the clerk's office representing the board of canvassers as an ex-official member, would have had instant knowledge that that candidate was not eligible. And more than a courtesy, maybe by duty, by obligation, and by the ability to inform either party. This is not just because it's the Democratic Party. I would expect that they would do the same thing for the Republican Party, and I would have no objection should that be the case. That's fair, and I think reasonable allowance. So this issue, Mr. Chairman, members of the Commission, I think has significant repercussions. It runs to the fact that due to incompetency or inability or untraining or whatever the reason, the Democratic Party has lost its standing and its ability to replace. And it doubled down on that incompetency. This is why I keep repeating this. It wasn't just that the day elapsed and I wasn't given notice. And therefore the second day elapsed and I wasn't given privilege to replace. Notice was not given to I, therefore the public. This is about the public too. Till one day after a document was prepared for the ability for candidates to pick up and begin the prospect of circulating for signatures. One day later, this became a public document. So now there's been a depriving and disenfranchising of the public as well. So having said that, I'm not represented by counsel today, but I expect that I would present to you information, documents, and citations if you need as a follow.
Do you have anything else that you want entered into the record other than the letter?
The letter speaks for itself. The citations I included in the letter of the general laws, I have copies, but I noticed that they were in the packet, so they are there for reference by the board members.
And for the record, the voter registration card of the candidates that withdrew, Joshua and Michael Accetturo, should be entered into the record. And voter registration signed by him on 6/22/24. Do any of the board members have any questions for Mr. Mancini?
No, he pretty much states everything in his letter. Any questions, John?
So we also have correspondence received from Chairman Bellotti. So
Okay, Chairman Bellotti?
Yes. Hi. Chris Bellotti, I'm the chair of the Republican Town Committee. Thank you for the opportunity to speak. I wrote a letter here that pretty much, I think, details the reasons that Mr. Accetturo was not qualified to be a candidate at the time that he sought to be a candidate. I don't think that's in dispute here, so I'm not going to go through the detail of why he's not qualified or wasn't qualified at the time, and I don't think, based on Mr. Mancini's testimony, that he would dispute that if he were ineligible, that Mr. Mancini would not have an opportunity to replace him. It seems like Mr. Mancini is only disputing the fact that he wasn't aware that Mr. Accetturo was ineligible, and that because the clerk didn't notify him that he should have an opportunity to replace him, despite the fact that the law precludes that. And I just want to point out a few things. Number one, Mr. Mancini mentioned that he's been the chair of the Democratic Town Committee for over 20 years now. I would think that he would know the law. He also testified that the candidates were asked if they qualified at the time that they were put on the time that the names were filled out on the nomination papers, and they all said yes, which bodes the question of whether Mr. Accetturo knowingly lied when he signed that form. So there's a few, legal issues here, but and the third thing, and I haven't looked at the statute, but Mr. Mancini referenced the statute, is that when you submit the names, you have 24 hours to submit a declaration for a replacement candidate. If you're notified that one of the candidates was not qualified, he complained that he wasn't notified until July 3rd, but I wonder if he designated a replacement candidate on July 5th, which would have been the next business day. And the fact that we're here now, I suspect that was not the case. And so even if you say that he should have been notified immediately by the town clerk, the fact that he was notified on the 3rd and did not try to take advantage of the 24-hour notice rule and submit a replacement candidate on the 5th, I think all of that, and primarily the fact that the law is the law and it does not make an exception for whether he was notified or not. If the clerk had made a mistake, that's unfortunate, but he did have an obligation to know the law and check to make sure the candidates that he had qualified. All of that information is public record. You don't need to be a town clerk to check. It's all available on the Secretary of State's website for the Board of Elections. The fact that he did not is unfortunate. And I just want to add also that he's claiming that they're being denied their rights. The state does provide for relief, and that's in my letter as well. Mr. Accetturo and/or a replacement candidate can run as a write-in candidate. Either they miss the timing for filing to be on ballot. And so, based on those facts, I obviously oppose any replacement candidate to be named for this election.
If I may, Mr. Chairman. I cited my length of time in party position to explain that over the time that I had never not had the opportunity, should this occur, and never have been not given notice that the candidates were accepted. Whether that seems to be a courtesy, it more likely looked to me like it was a process that was in fact used everywhere. I've checked with all the board of canvassers, and I asked them, what is the process when you receive a declaration from a candidate? And I've been told the first thing is we never send the candidate away. That's not our rule. Our rule is to accept it and then verify. So that happened in our case. While it wasn't the main candidates, it was the party town members. Why I'm saying that is because we had an expectation that if there was one candidate that wasn't on, we should have known. 17-12-2 provides for that relief the next day. Because that declaration period ended on the 27th, 26th, the next day was the 27th. When we learned about this on July 3rd, the holiday occurred on July 4th. Under advice I gave to Mr. Accetturo, he decided he was going to withdraw. That withdrawal letter occurred on July 5th, the very next business day. There was no presumption on my part that I would have the right or the ability to name a replacement, although I had already secured that. Your clerk had asked me, do you have the name of the party that you would probably submit? I did. As soon as she asked for it, I submitted it to her. But from my perspective, I did not know whether this would result in a hearing or whether I would be given that opportunity. It would be under 17-12-2, which says the next day after the last day of declaration. It doesn't say July 5th and you come in on July 8th to do that. So I didn't want to be presumptive, I just wanted to be accurate in what the next steps were. While I would love to have that privilege and that interpretation, I don't think that's where I was headed with that. So having said that, I once again reiterate our position on the Democratic Town Committee that we would deny due process, we would deny the ability to replace, and we're seeking that opportunity.
Thank you. Is there anybody else that would like to speak? So you basically have two issues in front of you. First issue is whether the clear Democratic candidate who is ineligible to file a declaration of candidacy pursuant to Rhode Island General Law 1713 and 1742 be deemed a nominee of a political party subject to replacement by a state or local party chairman under provisions of 1715-38. And the next issue is whether the Town of Smithfield Board of Canvassers should be stopped from denying the Smithfield Democratic chairman from replacing candidate Accetturo as a result of the town clerk's failure to notify him of candidate Accetturo's ineligibility prior to the close of the candidate declaration period, which precluded the chairman from availing himself of the provisions of 1712-2. Obviously, this is a quasi-judicial hearing. Any appeal would go of this decision would go to the State Board of Elections. So this board is charged with making some findings based on the representations that were made today and applying the law to those findings. As far as the law is concerned, you have it in front of you. It's basically 1713 and 1714-2 require that a candidate is ineligible to run for office, for local office, unless they have been a resident and registered voter within 30 days of the declaration period. Mr. Accetturo did not file his declaration of candidacy, did not register to vote until Saturday, the Saturday before 2 days before the declaration period started. So obviously, both sides agree that the candidate is clearly ineligible. Okay? The requirements of the statute are mandatory. You shall not be a candidate. You shall not be able to be a declared candidate unless you were registered 30 days prior to the declaration period. So you can't waive those requirements at all. Legislature's mandated those requirements. It's a very unfortunate circumstance as to what happened here. It's clear there was some sort of communication breakdown. The other issue that Mr. Mancini raises is addressed, he raises 1712-2, which is more of an estoppel argument, an equitable estoppel argument, that the town should not prevent him from being able to appoint a substitute candidate based on the provisions of 1712-2 and the fact that the declaration period was allowed to expire. He wasn't notified until the close of, actually until July 3rd, 6 days after the declaration period ended, that this candidate was ineligible. As far as estoppel is concerned, the Supreme Court has ruled on this issue through a series of cases. One being Paul Romano versus the State Retirement Board back in 2000 or 1999. And that was a case where an individual who retired from state employment, he retired, and at the time he retired, he had a job lined up with the city of town of Bristol to be their new public works director. He wanted to make sure that his pension would not be suspended based on the fact that he was taking a municipal job. So he was already in the state employee system, goes to the municipal system. I want to be able to work full time, not 75 days, what the law requires. So he reaches out to the head of the retirement system, says, no, you're okay, you're all set, you can do it. 9 years later, they do an internal audit, they find that he's so-called double dipping. And they say basically we're going to suspend your pension all the time during the time in which you are employed on a full-time basis for the city of Bristol. He challenges it. So there was clearly a representation was made. In this situation, there's a question as to whether or not this Smithfield Democratic Party or the Republican Party should have known whether or not their candidates were eligible to be declared candidates under the law from the beginning. Whether or not that didn't happen here, what happened is that failure to catch that mistake was compounded, by the clerk's office. But as far as Romano was concerned, if the clerk's making representations such as printing up nomination papers with, even though it was improper, with an ineligible candidate's name on it, there's no basis for reliance on those representations in the sense that the clerk's office was acting in an ultra-virus capacity. They were acting outside their actual authority, the scope of their actual authority. And their actions were in contravention of the state statute. State statute basically says you can't be a declared candidate unless you're a registered voter within 30 days prior to the declaration period. So there were a series of oversights that were compounded, obviously, by the clerk's office, it looks like, oversight over here. And but the representations that came out of that clerk's office based on the printing up of the ineligible candidate's name on declaration papers don't rise to the level of reliance that the Supreme Court has addressed in a number of cases, that the town's not going to be equitably stopped based on municipal officials who acted outside of the scope of their employment authority and in a manner that was inconsistent with state law. I mean, that's an overview of the law. There were certain factual findings that should be entered over here, including the two letters from both of the party chairs, the voter registration card of Mr. Accetturo, and there should be a chronology the following 10 items. So everything is in sync over here as far as if this record were to go up on appeal, depending on what this board does. Joshua Michael, finding number one should be Joshua Michael Accetturo registered to vote on the town of Smithfield as a registered Democrat on Saturday, June 22nd, 2024, 2 days prior to the statutory candidate declaration period. 2. On June 24th, 2024, the Smithfield Democratic Town Committee, based on Mr. Mancini's letter, conducts its endorsement meeting for local candidates. 3. The Smithfield Democratic Town Committee endorsed Joshua Michael Accetturo as one of 5 Democratic Council candidates. 4. On June 26, 2024, the last day of the statutory declaration period, the chairman of the Town Democratic Party, Lawrence Mancini, submitted the names of all endorsed local office candidates to the town clerk's office at 8:40 a.m. 5. At the time of the submission, neither the chairman of the Democratic Party nor the town clerk's office were aware of the fact that council candidate Accetturo was ineligible to be a candidate for council by virtue of the fact that his candidacy failed to comply with the provisions of Rhode Island General Law 17-1-3 and 17-4-2, and that candidate Accetturo only registered to vote for the first time and declared his party affiliation 2 days before the commencement of the declaration period. 6. At the close of the declaration period on June 24, 2024, neither the office of the town clerk nor the Smithfield Democratic Party realized that council candidate Accetturo was statutorily ineligible to be a candidate for town council. 7. On July 2, 2024, the town clerk's office prepared nomination papers of all 5 Democratic endorsed council candidates, including the ineligible council candidate, Mr. Accetturo. On July 3, 2024, at 11:55 a.m., Town Clerk Lynette Antonuccio notified Chairman Mancini that Joshua Accetturo was ineligible to be a candidate for Town Council as a result of Rhode Island General Law 17-1-3 and 17-4-2 within the Town of Smithfield because candidate Accetturo was not a registered voter within the Town of Smithfield at least 30 days prior to the declaration period. 9. On July 5, 2024, declared candidate Joshua Accetturo, upon learning of his ineligibility, attempted to withdraw his candidacy for town council before the July 15, 2024 withdrawal of candidacy deadline. 10. On July 15, 2024, Chairman of the Democratic Party, Lawrence Mancini, submitted the correspondence already identified by the town clerk and incorporated into the record, asking the board to fill the vacant candidate position of the on the Democratic Council slate of the endorsed candidates created by the ineligibility of candidate Accetturo. And the final number 11 would be that the town clerk hereby acknowledges and receipt of correspondence from Mr. Bellotti dated yesterday objecting to the Mr. Mancini's request.
So Mr. Mancini did not submit that name until yesterday?
No, Mr. Mancini submitted the name. When did the substitute?
I'd have to check the date, but I did question the name, and there was a name, but I didn't have any formal.
Letter?
Correct.
I was asked by email about the question, please provide the name.
Correct.
I replied immediately, constituting a notice for the clerk, I believe it was Monday, July 8th.
The hearing's still open, so you can.
So, just wanted to, one thing, Mr. Mancini testified to the fact that he asked each of the candidates individually if they were eligible before they signed the declaration form and before he submitted it. And so my question is, did Mr. Accetturo knowingly lie when he completed that form? And why not, if the rules were explained to him at the time?
In the candidate's nomination process, a 5-member nominating committee, which I am ex officio, but I'm not a voting member, asks a standard list of questions of every candidate. Are you a registered voter? Are you a registered Democrat? Yes. Is there anything in your background that would preclude you from running? You have to answer that question, whether it's a prior legal matter or unpaid taxes, and then a whole host of questions associated with the process. So the question was asked, individually but generic to the process. It wasn't expected that a demonstration of the registered voter would be submitted, and that happens on a regular basis. When you're seeking candidates in this process, and sometimes you have difficulty finding candidates, you, under the press of business, you accept at face value. The person said they're registered voter, you accept it at face value, expecting that there would be a process for verification and vetting. That process occurs at the government level, the clerk's office, who I believe is the gatekeeper of that process.
I would say that we are aware of the law and we check ourselves before we sign those papers to make sure that all of the candidates that we submit qualify before we submit. And we would not sign the declaration forms ourselves without verifying that first. And so, I think that obviously some responsibility rests with Mr. Mancini and Mr. Accetturo to know the law. And so, whether the clerk had any fault or not, the statute that he, was referring to for relief gives him 24 hours, and he did not submit a replacement candidate within 24 hours of being notified that Mr. Accetturo was not eligible. Instead, he just submitted, or Mr. Accetturo submitted a withdrawal within 24 hours. No form of declaration form was submitted.
Mr. Chairman, 1742 says within 24 hours of the last day of declaration. That declaration by statute is the last Monday, Tuesday, and Wednesday of the month of June. The date itself may change because of the calendar, but it's always the last Monday, Tuesday, and Wednesday of the month of June, an even year. And the law reads, the replacement provision conducted within 24 hours of the last day of declaration, not the day after the nomination papers were submitted in error, and notice was given that day later. We would deny that due process, and I humbly submit to you that there was a gross negligence. I don't even think ordinary care was exercised, let alone due diligence in the process.
So he did argue it was more of a reliance argument. Another Supreme Court case that's indirectly on point, basically standing for the estoppel legal principle that Mr. Mancini is arguing. It kind of supplements the case that actually, the case I cited originates out of this case going back to 1970. And the name of that case is Farrelly versus Department of Employment Security, 261 A. 2nd 906. And in that case, the Supreme Court again goes on to address the actions of municipal officials that are in conflict with state law. And the Supreme Court in that case basically said that neither a government entity nor any of its representatives has any implied or actual authority to modify, waiver, nor state law that conflicts with its actions or representations. Here, obviously, nobody in the clerk's office picked up the fact that the candidate was ineligible, but the mere fact of printing those nomination cases with an ineligible candidate on it conflicted with a state law that said you have to be a registered voter within 30 days. You shall be a registered voter within 30 days of the declaration period in order for you to be eligible to run for office. So it's a mistake that was, or oversight that was compounded over here. And
If I may, Mr. Solicitor, I certainly appreciate your knowledge and your competency. There are multiple parts to this, so it's about notice, it's about being timely, and the competency of that. And I do believe 1714.1 has an element of that. When it says that the signature must be verified, that's a verification process. That's a process within the multi-steps of whether or not a candidate submitted a form in a timely manner and one that was bona fide and eligible. There should have been that process. That process should have been enacted, and that process should have revealed that this candidate is not eligible. This candidate is not registered at the time. Courtesy to the candidate or contact to the party chair would have provided either in that day or clearly within the 24-hour period provided by 1712.1 the ability to replace some of the authority of the state chair. That was not granted. Why I cite the date of July 3rd. Not that notice elapsed on June 27th, the 24-hour date. the incompetency of going forward and preparing the paperwork, releasing it to the public, beginning the circulation process, nominee included who was in Millwood, and then notice given the next day.
If I may, there's a, I'm not sure if the case law is, I couldn't cite case law, of course, but, I was a CPA for 15 years. I was I don't know if he's a CPA or not, he's the chief financial officer, so he's got an accounting background. There's a lot of tax statute that refers to reliance on the advice of a professional CPA or whatnot. And the question always comes up is, should that person have relied on that advice or that information, and if that person knew or should have known the law, then I don't think reliance is a viable objection here.
So, Mr. Chairman, while we're not practicing accounting, we are clearly practicing good government. We are clearly practicing good government. We're concerned about disenfranchisement, failure to notice, denial of due process, incompetency of seasoned individuals who should have known and could have taken that steps. By the way, past practice is just as good in many cases. Past practice has always been established, including by the present clerk, who was not a big levy. That was more than a courtesy. It was a check and balance of their own work to say, hey, this person not. I saw a live demonstration of how quick it takes to discover that. Add to the last name, the next three alpha Qs of the first name. It's either A, I, or P. If it's B, pick it up. How hard did it take to confirm 7 names, 4 which were already held in the community, 3 newcomers?
How hard would it have been for you to do that before you submitted?
We relied on the ability of the election systems, which I don't have access to.
Anything further from anyone?
To be able to hold a meeting within 24 hours and then get an alternate candidate under the law if the person was objected. You would have had that emergency meeting. Did you have any emergency meetings?
Mr. Chairman, if I may, to that point. The Smithfield Democratic Town Committee at its nomination meeting always invokes a rule, a provision, and a privilege that says we hereby grant the party chairman the ability to nominate and endorse in any instance where it would be necessary. Typical example is a straggler walks in on Wednesday the 26th and files for town committee. We'll use that as an example. And we weren't aware of that. Maybe just a disinterested party who wants to go to town committee. We, by everything in our power, would not engage in a party primary for one seat that we don't know. What we do, endorse them, put them on the endorsement paper, file the paper with the clerk, who I know can attest that that's a process that we use season over season over season to avoid the expense of a party primary because somebody walked in as a strike. The town committee gives the chairman that privilege by a vote of its members on the evening of the nomination to say that should any change occur immediately, the party chair has that authority. So to Mr. Bellatti's point, authority was granted to me to act on my own.
So you have the 2 letters before you. You have a request from Mr. Mancini asking that a substitute candidate be, new candidate be substituted for the alleged withdrawal of Mr. Accetturo. And he cites the ability to do that under 2 different provisions, 1712-2, which was a 24-hour period that everybody was just talking about, which is more of an estoppel argument against the clerk's office, and 1715-38, which would basically make you determine whether or not a candidate who was an eligible candidate from the outset could even be the nominee of a political party.
And if I may, Mr. Solicitor, I apologize, Mr. Chair. I'm reflecting on Mr. Bellatti's point of why didn't I submit a name immediately? Well, I had the name. Well, holding the hearing today on the 18th, it was already noticed to the Observer 3 weeks ago that this would be held today. And I reached out, I believe I was seeking opinion from the solicitor that would this matter be added to the agenda so we amended. So the passage of that time should not be reflective of I, in my capacity, not acting as immediate as I could. Because if the provision is, while it wasn't one day after the 26th of June, which could have happened on the 17th, 12th, 2 notice, why didn't you file it immediately one day after you were notified? Well, that one day was the holiday, July 4th. The candidate of his own accord walked in on the 5th. I had to seek some guidance. Would I be given that privilege? Is there going to be a hearing? So all matters that follow were pending this hearing. All decisions pending this hearing.
For purposes of the record, the following statute should be entered into the record. 1713, 1714-2, 1714-15, 1712-2, 1715-38.
Seventeen, 1931, which talks about the ability to have a write-in as a relief.
You can add that one.
What was the number?
That's in my letter, 17, 1931.
So the first question here is whether or not he's even legally eligible to withdraw.
Can a candidate that was ineligible to file a declaration of candidacy from the very outset be deemed a party but nominee subject to withdrawal under provisions of 1715-38, which would allow Mr. Mancini to obtain a letter from the party chairperson submitting a substitute candidate.
And if he's not eligible to withdraw in the first place, he's then not eligible to be replaced.
Correct. Somebody would have to make a motion. There's only the two of you, so the chair is presiding, so he shouldn't be making any motions.
Based solely on the law and the Supreme Court case on point, I don't think we can accept the Democratic Party's motion or request. I'll make a motion to deny.
As much as I think there was fault here on the clerk office and somewhat on the chairman's, his point that had he been notified, he would have been able to submit a replacement. But because of the law, and I don't see anything that we can do contrary to the law, I would have to agree in.
So, Mr. Giacomoni made a motion, that motion would have to be
I would
seconded.
second that motion.
Is there any more discussion on that motion?
My discussion was what I had just said. That's all.
There were several points ahead of this meeting, or ahead of the clerk notifying him that the candidate wasn't eligible, that this could have been caught by the party, by the clerk's office, by the candidate himself, and it just didn't happen.
So there's a motion and there's a second.
All in favor? Aye.
So the second issue would be the reliance issue. And whether or not the chair has the ability to appoint a candidate pursuant to 1712-2, which would Mr. Mancini has basically gone on record and given you an accurate chronology as to everything that happened over here. Whether or not under that provision, if he was properly notified prior to the end of the declaration period that his candidate was ineligible, he would have a certain amount of time, 24 hours, within which to name an additional candidate on his own, okay, without the state party chair being involved. And whether or not the chronology of events that happened within the clerk's office, the issuance of nomination papers with the ineligible candidate on it, Mr. Mancini not knowing until 6 days after the declaration period ended, whether or not those reliance arguments basically would give him the ability to utilize that provision of the state law to appoint a substitute candidate. We went through the issues on reliance in the Supreme Court case. They govern those principles. As unfortunate as the situation is, those provisions are clearly addressed by a line of Supreme Court decisions. Although they don't deal exactly with election law, they deal with representation being made by municipal officials.
And again, just because of the Supreme Court case on point, it seems like this is just the gap in the law where a situation like this isn't covered, that it just wasn't conceived that this would be encouraged that happens, where someone who isn't eligible becomes a nominee, and then is later to be found ineligible. Can that person then be replaced? That's not addressed at all within the law.
So,
I would agree with that. The person was not eligible to begin with. The fact that Mr. Mancini did not know that has no bearing there, I don't believe.
so there will be a motion.
So again, I'd have to make a motion to deny.
Second.
Any discussion on the motion?
All in favor? Aye.
Anything else?
Close the agenda, motion to adjourn,
So moved.
second. All in favor?
Aye.
Aye.